we don't want to underestimate or minimize those complexities, and that's one of the reasons why we are working so hard and intensively on this negotiation with our US interlocutors. But that's not the only thing we have done in the past months. We have, I think, and that has been welcomed by stakeholders, including by the business community, modernized significantly the standard contractual clauses, including on those aspects where we have tried. We cannot substitute, of course, ourselves to the assessment that companies need to do, but where we have provided companies with a checklist of criteria, factors, parameters that need to be taken into account when carrying out that assessment of their transfers. We have also worked, and that was significantly commented, worked very hard and very closely with the EDPB to make sure that the recommendations they issued was convergent with the approach we adopted in our SCCs, in particular on questions around government access. Therefore, I think that has helped. I'm not saying that it's it's sort of the magic solution that makes everything easy, but that compared to a few months ago, a company that needs to indeed carry out that assessment has a number of useful tools. There too, it's interesting to see that we are not alone. Model clauses, because they present a number of benefits, including the sort of off-the-shelf nature, are increasingly used by other systems. We have seen SCCs being recently adopted in New Zealand, for instance, SCCs or model clauses being adopted by ASEAN, the Association of South Asian countries. And this issue of governance access, we understand its difficulty, its complexity. Of course, companies are neither legislature or governments, but this question of government access will not go away, because it is, and not only because of Schrems II, but for the reasons I've briefly mentioned before. It is a decisive issue, and an issue which is seen increasingly as a distinctive feature between democracy-like-minded countries and other regimes in the world. And it needs to be factored in an assessment of transfer. We are trying to our, if you want, unilateral instruments such as SCCs, but also to our bilateral or multilateral work such as the OECD, to try to develop a common understanding of these issues, common standards, common principles, so that companies will be able to rely on them when looking at a certain transfer at a certain country. As you've seen also in our SCCs, we have tried to stick as much as possible to what is our understanding of the court's ruling in Schrems II, which is an understanding, that this is not a binary issue, that you can have transfers to a certain country, which in light of a number of factors, such as the nature of the data, such even with a number of caveats and conditions, the experience of the importer in that system, the answer to the question and to the outcome of the assessment of the risk associated to the transfer may vary. I think that's an important element which needs to be taken up into account, and which has also been endorsed by the EDPB in its recommendations.